Please be seated. The sitting is open. The court meets today pursuant to Article 67 of the statute to deliver its advisory opinion on the request submitted by the General Assembly of the United Nations on the question of the obligation of Israel in relation to the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territory. Judge Bandari, who attended the oral proceedings, could not participate in the deliberation and the vote on the advisory opinion. I note the presence of the representative of the many states and international organizations that have taken part in these proceedings. The question on which the advisory opinion of the court has been requested is set forth in Resolution 79/232, adopted by the United Nations General Assembly on 19 December 2024. The question submitted to the court read as follows, I quote, "What are the obligations of Israel as an occupying power and as a member of the United Nations in relation to the presence and activities of the United Nations, including its agencies and bodies, other international organizations, and third states, in and in relation to the occupied Palestinian territory, including to ensure and facilitate the unhindered provision of urgently needed supplies essential to the survival of the Palestinian civilian population, as well as of basic services and humanitarian development assistance for the benefit of the Palestinian civilian population and in support of the Palestinian people's right to self-determination." End of quote. In accordance with the usual practice, I shall not read out the introductory paragraphs of the opinion. These paragraphs set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall therefore begin the reading of the advisory opinion at paragraph 17. The full text of the opinion will, of course, be available at the close of the sitting. The court first considers whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why it should, in the exercise of its discretion, decline to answer the request. The court notes that by virtue of Article 96, Paragraph 1 of the Charter, the General Assembly may request the International Court of Justice to give an advisory opinion on any legal question. The court considers that the question submitted to it is a legal question within the meaning of Article 96 of the Charter and Article 65 of the statute. The court concludes that it has jurisdiction to render an advisory opinion as requested by the General Assembly. Turning to discretion, the court recalls that only compelling reasons may lead it to refuse to give its opinion in response to a request falling within its jurisdiction. The court focuses on arguments that were either not addressed in its advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem, to which I shall refer as the 2024 advisory opinion, or that arise from the distinct legal and factual context of the present proceedings. The Court first considers the argument that the question put to it is premised on allegations that are currently under consideration in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel, and that giving the advisory opinion might prejudge elements relevant to that case. The Court does not find this argument convincing, as there is a clear difference between the respective subject matters of the two proceedings. In the present advisory case, the Court's mandate is limited to the identification of Israel's obligations as an occupying power and as a member of the United Nations in relation to the presence and activities of the United Nations in and in relation to the occupied Palestinian territory. By contrast, the contentious case between South Africa and Israel concerns the question whether Israel has violated its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, to which I shall refer as the Genocide Convention. The distinction between the two proceedings is unaffected by the fact that the Court's orders indicating provisional measures in the contentious case direct Israel inter alia to ensure the provision of basic services and humanitarian assistance to the population in the Gaza Strip. The measures indicated seek to preserve certain rights that the Court found to be plausible under the Genocide Convention. Although the same conduct may be required of a state under different legal rules, and the same conduct may simultaneously breach multiple obligations, a determination made by the Court in the context of one obligation does not necessarily prejudge the question of compliance with a different obligation. Here, the facts that are relevant to a potential finding of a violation of obligations under the Genocide Convention are sufficiently distinct from the facts that are relevant to the determination of Israel's obligations as an occupying power and as a member of the United Nations in the present context. There are, however, factual and legal matters that may be relevant both in the present advisory proceedings and in contentious proceedings. In this respect, the Court recalls that the parties to pending contentious proceedings will have the opportunity to present evidence and arguments on questions of fact and law on the basis of which the Court will decide in those proceedings. The Court then turns to the argument that the question put to it has already been largely addressed in its previous advisory opinions on the legal consequences of the construction of a wall in the occupied Palestinian territory and on the 2024 advisory opinion. The Court considers that the current request differs from the earlier ones and concerns a question that was not addressed in the previous advisory opinions. First, the present request pertains to a specific issue that had not emerged at the time of the earlier advisory opinions. As recounted in the preamble of Resolution 79/232, the General Assembly's request was approved following Israel's adoption of legislation on 28 October 2024, curtailing the operations of the United Nations Relief and Works Agency for Palestine Refugees in the Near East, Unrwa. Second, the 2024 advisory opinion was limited ratione temporis to policies and practices taking place before 7 October 2023, By contrast, the present request concerns conduct taking place after that date. The court then examined the argument that the request would require it to undertake significant factual investigations and make findings on disputed and evolving matters which cannot properly be pursued in the framework of advisory proceedings. The court notes that the case file contains ample documentation concerning the relevant facts. In the present case, the court considers that the information available enables it to decide legal questions in a manner consistent with its judicial function. Finally, the court rejects the argument that the request abuses and weaponizes the international judicial process. Even if allegations of abuse of process could be advanced in the context of advisory proceedings, the court does not consider that there is any basis for such a finding in the present case. The court concludes that there are no compelling reasons for it to decline to give the opinion requested by the General Assembly. The court then outlines the general context of the opinion. It recalls the historical background of the situation with regard to the occupied Palestinian territory. The court next discusses how the United Nations, and in particular the General Assembly, became involved in the provision of humanitarian assistance to Palestinian refugees, both Arab and Jewish. It notes inter alia the establishment of Unrwa in 1949 and the commencement of its operations in 1950. On 14 June 1967, Unrwa and Israel concluded a provisional agreement concerning assistance to Palestinian refugees in the occupied Palestinian territory, to which I shall refer as the 1967 agreement. The 1967 agreement provided that Unrwa would continue its assistance to Palestinian refugees with the full cooperation of Israeli authorities in the West Bank and Gaza Strip areas, and that Israel would facilitate the task of Unrwa to the best of its ability, listing a number of commitments taken on by Israel. According to the United Nations, over its 75-year history, Unrwa has become a pivotal agency for relief and assistance to Palestinian refugees in the occupied Palestinian territory. Its mandate has been extended pursuant to successive General Assembly resolutions, the most recent of which extended the mandate of Unrwa until 30 June 2026. The court observes that other UN agencies, United Nations agencies and bodies, specialized agencies, international organizations, and third states also provided assistance in or in relation to the occupied Palestinian territory. The court then recalls that on 7 October 2023, Hamas and other armed groups present in the Gaza Strip carried out attacks in Israel, killing more than 1,200 people, injuring thousands, and abducting 251, some of whom continued to be held hostage for more than 2 years. Following these attacks, Israel launched a large-scale military operation in the Gaza Strip by land, air, and sea, which has caused massive casualties, including the deaths of tens of thousands of civilians, a large number of whom were women and children, extensive destruction of civilian infrastructure, and the repeated displacement of the overwhelming majority of the civilian population in the Gaza Strip. In the course of its military campaign, Israel has substantially restricted and for significant periods of time, including between 2 March and 18 May 2025, completely prevented the entry of aid into the Gaza Strip and its distribution to the Palestinian population, with catastrophic consequences for this population. The United Nations reported numerous attacks on school buildings and healthcare facilities in the Gaza Strip, operated by the United Nations and others, including school buildings that have been directly hit. The Secretary General of the United Nations has stated that between 7 October 2023 and 20 August 2025, at least 531 aid workers, including 366 United Nations personnel, 360 of whom were employed by Unrwa, have been killed in the Gaza Strip. In January 2024, Israeli authorities alleged that a number of Unrwa employees had been involved in the 7 October 2023 attacks, that Unrwa premises had been appropriated by Hamas for military purposes, and that Unrwa had long lost its neutrality. The United Nations immediately took steps to investigate these allegations. In this connection, the Court discusses the investigations conducted by the Office of Internal Oversight Services of the United Nations, to which I shall refer as the OIOS, and the investigation by an independent panel set up to assess whether Unrwa was taking all reasonable steps to ensure its neutrality. Notwithstanding these steps, Israel has maintained its complaints about Unrwa. On 28 October 2024, the Parliament of Israel, the Knesset, adopted 2 laws entitled the Law to Cease Unrwa Operations and the Law to Cease Unrwa Operations in the Territory of the State of Israel, respectively. The Court notes that the second of these laws purports to apply to East Jerusalem. By a letter dated 3 November 2024, the Ministry of Foreign Affairs of Israel informed the President of the General Assembly that Israel had withdrawn its request to Unrwa to provide humanitarian assistance to Palestinians pursuant to the 1967 agreement. According to Israel, that agreement was terminated. By a letter dated 24 January 2025, Israel informed the Secretary General that Unrwa had to cease its operations in East Jerusalem and evacuate its premises there no later than 30 January 2025. The 2 laws on Unrwa, adopted by Knesset, entered into force on that date. The Court recalls that Israel did not allow any aid to reach the Gaza Strip from 2 March until 18 May 2025. Since 19 May 2025, the Israeli authorities have allowed the United Nations to resume the delivery of limited aid into the Gaza Strip. The United Nations and the Observer State of Palestine have, however, alleged that Israel has continued to impose substantial restrictions on the entry and distribution of aid and commercial goods into the Gaza Strip. They maintained that, as of the end of August 2025, the humanitarian situation in the Gaza Strip had become catastrophic, with evidence of famine, mass displacement, extreme levels of deprivation, and a continued increase in civilian casualties, including children. On 27 May 2025, Israel launched a new aid distribution system through a private foundation called the Gaza Humanitarian Foundation and a private security firm, with only a few distribution points, mainly in southern Gaza. Israel alleged that this new system was required to prevent diversion of aid by Hamas. The United Nations, other international organizations, and humanitarian non-governmental organizations considered that this new system did not align with humanitarian principles, did not meet people's needs, and put people at risk, and they refused to collaborate with it. Having given an overview of the humanitarian relief situation in the Gaza Strip, the Court then turns to the scope and meaning of the question posed by the General Assembly. The Court observes that the question concerns the identification of the obligation of Israel. The General Assembly did not ask the Court to determine the legal consequences of any breach of these obligations. For this reason, the Court does not consider that it is called upon to determine whether Israel has violated its legal obligations or to address the legal consequences of Israel's conduct, including under the law of state responsibility. The Court explains that identification of Israel's legal obligations cannot be undertaken in purely abstract terms and requires taking the particular situation under the request into account. Thus, the Court states that it will base its assessment on the factual situation and identify Israel's obligations with the degree of specificity it considers warranted to fulfill its judicial function. Turning to the territorial scope of the question, the Court notes that the question covers Israel's obligations in relation to United Nations entities, other international organizations, and third states in and in relation to the occupied Palestinian territory. Thus, in addition to Israel's obligations in the occupied Palestinian territory, the request also requires consideration of Israeli activities undertaken on Israel territory or elsewhere to the extent that they concern the presence and activities of United Nations entities, other international organizations, and third states in relation to the occupied Palestinian territory. The Court further observes that while the question encompasses Israel's obligations in the occupied Palestinian territory as a whole, due to the specific reference in the request to urgently needed supplies essential to the survival of the Palestinian civilian population, it will pay particular attention to Israel's obligations in the Gaza Strip. In terms of its temporal scope, the General Assembly's request does not include any limitations. Moreover, the Court is aware that the situation in the occupied Palestinian territory is evolving rapidly. The Court indicates that it bases its legal analysis primarily on the facts as they stood at the closure of the oral proceedings on 2 May 2025, as well as on the participants' replies to the questions posed during the oral proceedings, which were received on 7 May 2025. Additionally, the Court takes into account subsequent developments based upon the information presented to the Court at its request by the United Nations, Israel, and the Observer State of Palestine, which was received by 8 September 2025. The Court observes that the request concerns two main categories of obligations. Accordingly, the Court will first consider the obligation of Israel as an occupying power. Then the Court will turn to the obligation of Israel as a member of the United Nations. The Court recalls that an occupying power has a general obligation to administer the territory for the benefit of the local population. Israel's particular obligations as an occupying power in relation to the presence and activities of the United Nations, other international organizations, and third states are governed by international humanitarian law, in particular the law of occupation, and by international human rights law. With regard to international humanitarian law, the Court notes that Israel's relevant obligations follow from the Geneva Convention relative to the protection of civilian persons in time of war of 12 August 1949, to which I shall refer as the Fourth Geneva Convention, to which Israel is a party. As confirmed in the Court's jurisprudence, the Fourth Geneva Convention is applicable in the occupied Palestinian territory. Moreover, Israel has obligations under customary international law, notably as reflected in the regulations respecting the laws and customs of war on land, annexed to the Fourth Hague Convention of 18 October 1907, and in certain provision of the Protocol Additional to the Geneva Conventions of 12 August 1949, and relating to the protection of victims of international armed conflicts, to which I shall refer as the Additional Protocol 1. The Court emphasizes the fundamental importance of the principle of distinction under international humanitarian law. As a corollary to this principle, the Court recalls the principle of proportionality and also refers to the principle of precaution. The Court then discusses Israel's status as an occupying power in the Gaza Strip. The Court recalls that it found in the 2024 advisory opinion that after the withdrawal of its military presence in 2005, Israel remained capable of exercising and continued to exercise certain key elements of authority over the Gaza Strip, and that Israel's obligations under the law of occupation have remained commensurate with the degree of its effective control over the Gaza Strip. These findings were based on the control exercised by Israel over the Gaza Strip prior to 7 October 2023, including control of the land, sea, and air borders, restrictions on movement of people and goods, collection of import and export taxes, and military control over the buffer zone. Since that date, Israel's effective control over the Gaza Strip has increased significantly, as evidenced inter alia by Israel's increased military control in large portions of the territory and Israel's blocking of aid between 2 March and 18 May 2025, which prevented all humanitarian aid from entering into the Gaza Strip. Therefore, the Court finds that Israel's obligation under the law of occupation have also increased significantly, commensurate with the increase in its effective control over the territory. Those obligations include the obligations under the law of occupation considered hereinafter by the Court. The Court observes that the fact that hostilities are ongoing does not necessarily preclude the simultaneous application of the law of occupation. When hostilities take place in an occupied territory, the law of occupation applies alongside other rules of international humanitarian law relating to the conduct of hostilities, and the occupying power must comply with both sets of rules. However, the intensity of the hostilities could affect the implementation of certain obligations under the law of occupation, and therefore the particular conduct required of the occupying power. The Court next considers the relevance of Israel's security concerns, of which it is conscious. The Court observes that while certain provisions of the Fourth Geneva Convention and other rules of customary international law allow the occupying power to take consideration of security or military necessity into account, the protection of security interests is not a freestanding exception permitting a state to depart from the otherwise applicable rules of international humanitarian law. Any limitations on Israel's obligations under international humanitarian law based on its security concerns must be grounded in a specific rule. The Court underscores that reliance upon such concerns must be exercised in accordance with the principle of good faith. Further, the Court emphasizes that when states take measures to combat terrorism, they must comply with their obligations under international law, in particular, their obligation to respect international humanitarian law and international human rights law. Turning to the relevant framework under international humanitarian law, the Court observes that customary international law imposes a duty on all parties to an armed conflict to allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need, subject to a limited right of control. Such relief actions must be impartial in character and conducted in a non-discriminatory manner. More specific obligations apply in the case of occupation. Articles 55 and 56 of the Fourth Geneva Convention obligate an occupying power to ensure that the population of the occupied territory is supplied with the essentials of daily life, including food, water, shelter, medical supplies, and medical care. Article 59 imposes additional obligations that depend on the population being inadequately supplied. Recalling the particular context of this case, the Court begins its analysis with Israel's obligations under Article 59 of the Convention. The Court emphasizes that as the occupying power, Israel's obligation under the first paragraph of Article 59 to agree to and facilitate relief schemes if the local population is inadequately supplied is unconditional. Relief schemes under Article 59 may be undertaken either by states or by impartial humanitarian organizations. The provision thus places obligations upon Israel, both in relation to third states and in relation to the United Nations and other humanitarian organizations. These organizations must qualify as impartial to come within the scope of Article 59. The fourth paragraph of Article 59 accords certain rights to a state granting free passage to consignments. These include, inter alia, the right to inspect consignments and the right to be reasonably satisfied that these consignments are to be used for the relief of the deprived population. However, no state may exercise these rights to impede the delivery of relief consignments in a manner that undermines the performance of its obligations as set out in Article 59. An occupying power's obligation to agree to and facilitate the entry of humanitarian relief into an occupied territory under Article 59 does not displace its basic obligations to ensure the availability of food and medical supplies essential to the survival of the local population. Other provisions of the Fourth Geneva Convention confirm that aid can be impeded only temporarily and for narrowly circumscribed reasons. For example, the second sentence of Article 60 provides that, and I quote, "The occupying power shall in no way whatsoever divert relief consignments from the purpose for which they are intended, except in case of urgent necessity, in the interest of the population of the occupied territory and with the consent of the protecting power." End of quote. The specific conditions for allowing diversion of relief consignments under Article 60 are cumulative, and such action may be taken only in the interest of the local population. Thus, the Court emphasizes that the diversion of relief must remain exceptional, temporary, and only for the narrowly defined purposes set forth in the Fourth Geneva Convention. Any large-scale diversion of humanitarian aid constitutes a violation of obligations under the Fourth Geneva Convention. Moreover, diversion of aid must never undermine the general obligations of an occupying power to ensure that the population is adequately supplied. The occupying power may never invoke reasons of security to justify the general suspension of all humanitarian activities in occupied territory. The Court observes that the distribution of humanitarian relief in an impartial manner requires considerable planning and coordination. Thus, an occupying power must do more than simply allow the passage of essential items into the occupied territory. It must also use all means at its disposal so that these items are distributed in a regular, fair, and non-discriminatory manner, including by facilitating access to them and refraining from threats or use of violence or lethal force against the civilian population seeking to access such humanitarian relief. Relief schemes must be carried out in a manner that respects the dignity of the local population and that is consistent with the protection of the human rights of that population. The obligations contained in Article 59 of the Fourth Geneva Convention arises only when the whole or part of the population of an occupying territory is inadequately supplied. After examining the evidence, the court finds that the local population in Gaza Strip has been inadequately supplied within the meaning of Article 59 of the Fourth Geneva Convention. In such a situation, Israel, as an occupying power, is under an obligation to agree to and facilitate relief schemes under that provision. The court next considers Israel's obligations under Article 59 as they relate to Unrwa. The court observes that these obligations also apply to relief schemes provided by United Nations entities more broadly. The same is true, in principle, for other humanitarian organizations seeking to provide humanitarian relief in the Gaza Strip. The court recalls that Israel does not consider Unrwa to be an impartial organization and has argued that, as a result, Unrwa does not come within the purview of Article 59. The court observes that the qualification of a humanitarian organization as impartial or otherwise must be based on an objective assessment. It cannot depend only on the unilateral claim of the organization in question or on the unilateral perception of the occupying power. The court notes that based on the case file, there is no evidence that Unrwa as an entity breached the principle of impartiality within the meaning of Article 59. In other words, there is no evidence that Unrwa has discriminated with respect to nationality, race, religious belief, class, or political opinion during its distribution of humanitarian aid and provision of services in the occupied Palestinian territory. The court observes that while neutrality is not a separate requirement under Article 59, the two concepts are related, and neutrality plays a role in assessing the impartiality of the activities of humanitarian organizations. Israel alleged that Unrwa has been infiltrated by Hamas and other terrorist organizations, and that Unrwa employees took an active part in carrying out the attacks of 7 October 2023. Israel further alleged a widespread and systemic misuse of Unrwa's assets and facilities by Hamas. According to Israel, its concerns were not adequately addressed by the United Nations. The court considers that the information before it is not sufficient to establish Unrwa's lack of neutrality for the purpose of assessing its impartiality as an organization under Article 59. In particular, the fact that the OIOS investigation in 2024 led to the dismissal of 9 members of Unrwa personnel due to their possible involvement in the 7 October 2023 Hamas-led attacks against Israel is insufficient to support a conclusion that Unrwa as a whole is not a neutral organization. In addition, the court finds that Israel has not substantiated its allegations that a significant part of Unrwa employees are members of Hamas or other terrorist factions. The court notes that an occupying power is in principle free to choose the humanitarian organizations through which it fulfills its obligation to agree to and facilitate humanitarian relief. However, Article 59 limits an occupying power's discretion insofar as it requires that power to allow and facilitate sufficient relief to ensure that the population is adequately supplied. The court recalls that Unrwa has become the lead United Nations agency for relief and assistance to Palestinian refugees. in the occupied Palestinian territory and neighboring states, playing a critical role in the Gaza Strip. Unrwa has thus been deeply integrated into the local infrastructure of the occupied Palestinian territory, providing for the most basic needs of the local population, including food, potable water, healthcare, and shelter. The court recalls the scale and urgency of the needs of the population of the Gaza Strip and UNRWA's unique and sustained connection with the population of the occupied Palestinian territory. The court considers that in the current circumstances, it is not possible to replicate the capacity of the United Nations acting through UNRWA to ensure that the population of the Gaza Strip is adequately provided for. UNRWA cannot be replaced on short notice and without a proper transition plan. The court further observes that Israel itself has not ensured that the population of the Gaza Strip is adequately supplied. The court recalls that in addition to severely restricting the entry of aid at various times after 7 October 2023, Israel blocked the delivery of humanitarian aid in the Gaza Strip starting from 2 March 2025 and only allowed the delivery of a limited amount of aid to resume on 19 May 2025. The evidence thus shows that whether or not the operations of the United Nations acting through UNRWA were replaceable, Israel had no replacement system mobilized for a 10-week period. The Gaza Humanitarian Foundation, a purported replacement for UNRWA, has been widely criticized by the United Nations and other international actors, and its operations have been alleged to be inconsistent with core humanitarian principles. The United Nations observed in its response of 27 August 2025 that aid delivery remains significantly below the volume required to meet the needs of the population. According to the Office for the Coordination of Humanitarian Affairs of the United Nations, to which I shall refer as OCHA, over 2,100 Palestinians have been killed at or near the distribution sites of the Gaza Humanitarian Foundation since that system began operating on 27 May 2025. The court concludes that in the present circumstances, the United Nations, acting through UNRWA, has been an indispensable provider of humanitarian relief in the Gaza Strip. Having regard to Article 59 of the Fourth Geneva Convention, and in the circumstances, the court considers that Israel is under an obligation to agree to and facilitate relief schemes provided by the United Nations and its entities, including UNRWA. The court adds that Article 59 of the Fourth Geneva Convention refers to aid provided by states or by impartial humanitarian organizations. Thus, as long as the population remains inadequately supplied and Israel is not itself operating a system of humanitarian support that is in accordance with its obligations under international humanitarian law, Israel is obliged under Article 59 to agree to and facilitate relief schemes provided by third states or impartial humanitarian organizations such as the International Committee of the Red Cross. The court then turns to other obligations under international humanitarian law. As an occupying power, Israel is obliged to ensure the basic needs of the local population, including the supplies essential for their survival. Obligations to this effect are set out in Articles 55 and 56 of the Fourth Geneva Convention, as supplemented by Article 59, Part 1 of Additional Protocol 1. The Court observes that Israel's obligations under Articles 55 and 56 are not dependent on the local population being inadequately supplied, and therefore also extend beyond the Gaza Strip to other parts of the occupied Palestinian territory. In the Court's view, under these provisions, Israel is not only required to perform the positive obligation to ensure essential supplies to the local population to the fullest extent of the means available to it, but it is also under a negative obligation not to impede the provision of these supplies or the performance of services related to public health. In this respect, to the extent that Israel does not itself fulfill the obligations under Articles 55 and 56, leaving that responsibility to the United Nations acting through Unrwa, as well as other international organizations and third states, Israel is under the same positive and negative obligations to support and not to restrict the activities of those entities. The operation of the United Nations through Unrwa and those of other international organizations and third states have been central to Israel's performance of its obligations as an occupying power under Articles 55 and 56 of the Fourth Geneva Convention. Consequently, Israel's obligations under these provisions require it either to facilitate those operations or to otherwise ensure that these obligations are fully met. The Court next discusses the obligation of Israel to respect and protect relief and medical personnel and facilities. The Court explains that the principle that humanitarian relief personnel must be respected and protected forms part of customary international law. The activities of the relief personnel may be limited and their movement may be temporarily restricted only in case of imperative military necessity. Personnel participating in relief actions are also protected by the principle of distinction unless and only for such time as they directly participate in hostilities. The obligations of an occupying power exist alongside the obligations under international humanitarian law of all parties to a conflict to protect civilian hospitals and to respect and protect medical personnel exclusively assigned to medical duties in all circumstances. The Court then observes that the first paragraph of Article 49 of the Fourth Geneva Convention provides that individual or mass forcible transfers and deportations from occupied territory of protected persons within the meaning of that convention are prohibited, regardless of their motive. Deportation or forcible transfer of the civilian population of an occupied territory, in whole or in part, is also prohibited under customary international law. The Court recalls that transfer may be forcible not only when it is achieved through the use of physical force, but also when the people concerned had no choice but to leave. This may include inflicting conditions of life that are intolerable. While the second paragraph of Article 49 of the Fourth Geneva Convention allows an occupying power to evacuate people to a given area if the security of the population or imperative military reasons so demand, it provides that persons thus evacuated shall be transferred back to their homes as soon as hostilities in the area in question have ceased. The Court observes that the third paragraph of Article 49 further stipulates strict conditions for such evacuations. According to some participants, including the United Nations, the Israeli military has issued numerous displacement orders, forcing hundreds of thousands of people into overcrowded areas and restricting the United Nations' ability to deliver urgently needed essential supplies. The Court observes that Israel, as an occupying power, is prohibited from restricting the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territory to a degree that creates or contributes to conditions of life that would force the population to leave. The Court next recalls the provisions of Articles 76 and 143 of the Fourth Geneva Convention and concludes that Israel is obliged to allow the ICRC access to visit protected persons from the occupied Palestinian territory detained by the Israeli authorities. In its final section on international humanitarian law, the Court explains that custom international law prohibits the use of starvation of the civilian population as a method of warfare. As the Court has noted, Israel blocked aid into the Gaza Strip, preventing the entry of humanitarian aid into the region from 2 March until 18 May 2025. In the view of the Court, Israel's consent to operation of the Gaza Humanitarian Foundation since 27 May 2025 and to other limited humanitarian aid has not significantly alleviated the situation. The Court further refers to its finding that the local population in the Gaza Strip has been inadequately supplied. In these circumstances, the Court recalls Israel's obligation not to use starvation of the civilian population as a method of warfare. As an occupying power, Israel has obligation under international human rights law to respect, protect, and fulfill the human rights of the population of the occupied Palestinian territory. Restrictions on the provision of humanitarian aid that is indispensable for the well-being and dignity of the Palestinian population directly implicate these obligations. Israel is a party to several United Nations human rights treaties. These include the International Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Cultural, and Social Rights, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, the Convention on the Rights of the Child, and the Convention on the Rights of Persons with Disabilities. In the Court's view, the principle that the state's human rights obligations extend to acts taken by that state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories, applies with respect to all these treaties. Both the human rights treaties to which Israel is a party and customary international law encompass a wide range of human rights that are relevant to the population of the occupied Palestinian territory. These rights apply alongside the obligation of an occupying power under international humanitarian law, including the obligation under Article 27 of the Fourth Geneva Convention that protected persons shall be respected and humanely treated, and the specific obligations of an occupying power addressed earlier. Such rights include the right to life, the right to be free from torture or cruel, inhuman, or degrading treatment or punishment, the right to liberty and security, the right to freedom of movement, the right to protection of family life, the right to an adequate standard of living, including adequate food, clothing, and housing, and the continuous improvement of living conditions, the right to the enjoyment of the highest attainable standard of physical and mental health, the right to education, and the right not to be subject to discrimination on specific grounds. The Court has confirmed that Israel has a positive obligation to respect, protect, and fulfill international human rights in the occupied Palestinian territory, even in times of armed conflict. The Court observes that to the extent that the local population has been capable of enjoying many of these human rights in the occupied Palestinian territory, this has been largely enabled and ensured through the work of the United Nations, particularly through Unrwa, supported by the activities of other international organizations and third states. Consequently, any diminution by Israel of the capacity of Unrwa and these other actors to ensure these basic human rights means that the obligations of Israel to respect, protect, and fulfill these rights increases to a commensurate degree. In its advisory opinion, the Court recalls policies and practices of Israel that have resulted in the deprivation of the essentials of daily life for the local population of the Gaza Strip. The Court then discusses how the various rights it has identified may be engaged. The Court next turns to the obligations of Israel as a member of the United Nations. The Court starts by recalling the responsibility of the United Nations toward the question of Palestine, which was described by the General Assembly as a permanent responsibility until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy. The Court then discusses the obligation to cooperate with the United Nations. By virtue of Article 2, Paragraph 2 of the Charter, all members must fulfill in good faith the obligations assumed by them in accordance with the Charter. This provision must be applied in conjunction with the specific obligations assumed by the members in accordance with the Charter. In realizing the purposes of the United Nations, as enunciated in Article 1 of the Charter, members have a specific obligation to cooperate with the United Nations under Article 2, Paragraph 5 of the Charter, which provides that all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. This provision must be read together with the provision of the Charter relating to the powers of various organs of the United Nations. Compliance with this duty to render assistance is important for the effective functioning of the organization, the fulfillment of its mandate, and the independence and efficacy of its personnel in the discharge of their duties. Furthermore, members are under obligation to cooperate with the United Nations under Articles 55 and 56 of the Charter. The obligation of Israel and of all other member states to cooperate with the United Nations with respect to the question of Palestine is of paramount importance in addressing the critical situation on the ground since October 2023, in which the United Nations, together with other actors, plays a crucial role in delivering and coordinating humanitarian aid and development assistance to the occupied Palestinian territory, in particular through Unrwa in the Gaza Strip. The Court recalls that Israel, as an occupying power, is not entitled to sovereignty over or to exercise sovereignty powers in any part of the occupied Palestinian territory, including East Jerusalem. By enacting and enforcing the two laws adopted by the Knesset on 28 October 2024, that unilaterally terminated Israel's cooperation with Unrwa, including its operation in East Jerusalem, Israel continues to exercise sovereign power in East Jerusalem. Moreover, these laws have directly resulted in obstructions to the operations of Unrwa in and in relation to the occupied Palestinian territory, in particular in the Gaza Strip. Furthermore, the Court notes that Unrwa, as a subsidiary organ of the United Nations, has been entrusted by the General Assembly to provide direct relief and work programs for Palestine refugees. It cannot carry out such a mandate effectively without having direct access to the population in the occupied Palestinian territory. This is particularly true given the crucial role that Unrwa has been playing since October 2023. In the view of the Court, Israel is not entitled to withhold its cooperation with the United Nations by unilaterally deciding on the presence and activities of the United Nations entities in and in relation to the occupied Palestinian territory, subject to paragraph 184 of the advisory opinion. Lastly, Israel must fulfill its obligations in good faith. In the event of any difference arising between Israel and the United Nations, the obligation to cooperate requires Israel to pursue consultation and negotiation with the United Nations. The Court then turns to the obligation to respect the privileges and immunities of the United Nations. It refers first to Article 105 of the Charter of the United Nations. It adds that the privileges and immunities of the United Nations are further set out in the Convention on the Privileges and Immunities of the United Nations, to which I shall refer as the General Convention, adopted by the General Assembly pursuant to Article 105, paragraph 3 of the Charter. Israel acceded to the General Convention on 21 September 1949 without making any declaration or reservation. The Court emphasizes that the privileges and immunities accorded to the United Nations and its personnel are functional in nature. These privileges and immunities are not accorded as benefits to the United Nations or its personnel, but to safeguard their functions. The Court recalls that, as a general rule, the way in which a subsidiary organ established by the General Assembly is utilized depends on the consent of the state or states concerned, and that states possess a sovereign power of decision with respect to their acceptance of the headquarters or regional office of an organization within their territories. It follows that within the territory of Israel, the presence and activities of the United Nations and its entities are subject to the consent of Israel. However, in the occupied territory over which Israel, as an occupying power, enjoys no sovereignty, it is not entitled to decide unilaterally with respect to the presence and activities of the United Nations in and in relation to the occupied Palestinian territory in the same way as in its own territory. The Court is of the view that in the context of an occupation, an occupying power exercises jurisdiction and control over the occupied territory and thereby assumes an obligation to respect the privileges and immunities accorded to the United Nations under Article 105 of the Charter and the General Convention in the occupied territory. The Court considers that Article 105 of the Charter and the General Convention do not cease to operate in the context of armed conflict. This is consistent with the purposes and functions entrusted to the United Nations, which often carries out important missions in areas of tension and conflict. Pursuant to Article 105 of the Charter and the General Convention, pursuant to Article 105 of the Charter, General Convention sets out the privileges and immunities that the United Nations and its personnel enjoy in the overall performance of their functions. For the purposes of the present proceedings, the Court considers the following aspects and the corresponding provisions of the General Convention to be of particular relevance to the question put to it. First, the obligation to respect the privileges and immunities accorded to the United Nations, its premises, property, and assets. Second, the obligation to respect the privileges and immunities of United Nations personnel. And third, the obligation to address any concern regarding the privileges and immunities of the United Nations and its personnel within the legal framework of the United Nations. The Court then discusses these obligations in detail in the context of the occupied Palestinian territory. Concerning the obligation to respect the privileges and immunities accorded to the United Nations, its premises, property, and assets, Israel must respect the immunity from the legal process of the United Nations, its property and assets in and in relation to the occupied Palestinian territory. Furthermore, Israel must respect the inviolability of the premises of the United Nations, including its field offices in the occupied Palestinian territory, and not interfere with the performance of their functions. The Court considers that the question whether a particular facility in the occupied Palestinian territory qualifies as the premises of the United Nations must be assessed by taking into account the specific circumstances pertaining to each facility concerned. With respect to the question whether the schools, health clinics, and the hospital operated by Unrwa in the occupied Palestinian territory fall within the category of United Nations premises, the Court is of the view that what is pertinent is whether the function and services provided by these facilities form part of the mandate of Unrwa. If that is the case, in addition to its obligations under international humanitarian law, Israel is under an obligation to respect the inviolability of these premises in accordance with Article 2, Section 3 of the General Convention. The obligation to respect the inviolability of the United Nations premises and the obligation not to interfere with the United Nations property and assets must also be upheld in the context of armed conflict, as such inviolability and non-interference are essential to safeguarding the independent and effective performance of the functions of the organization under all circumstances. The Court acknowledges that the context of an armed conflict raises challenges, especially in the situation of potential loss of control by the United Nations over certain of its premises. However, it is for the United Nations to determine whether a particular facility remains the premises of the United Nations. In the view of the Court, such a determination by the United Nations of the present advisory opinion, the term United Nations personnel refers to its officials as well as its experts on mission. In and in relation to occupied Palestinian territory, Israel must respect the independence of United Nations personnel and the privileges and immunities necessary for the exercise of their functions. The Court considers that United Nations personnel are entitled to the privileges and immunities provided by Article 105 of the Charter and Articles 5 to 7 of the General Convention for all acts performed by them in their official capacity. It is for the Secretary General to determine whether a particular official or expert on mission is entitled to the privileges and immunities provided, and to assess whether that person acted within the scope of the person's functions. In the view of the Court, the Secretary General's determination of the scope of the official functions of the officials or experts in question creates a presumption that can only be set aside for the most compelling reasons and is to be given the greatest weight by states. In light of the foregoing, Israel is prohibited from taking actions contrary to its obligations under Articles 5 and 6 of the General Convention against United Nations officials and experts on missions operating in and in relation to the occupied Palestinian territory. In addition, Israel has obligations under the General Convention with respect to the free movement of United Nations personnel in and in relation to the occupied Palestinian territory so that they can carry out their mandated activities. The Court notes that in the context of the occupied Palestinian territory, the United Nations and its entities operating on the ground rely extensively on the contribution of local personnel. In this regard, the Court emphasizes that the free movement of local United Nations personnel for the performance of their official functions must also be respected by Israel. In concluding its analysis of the privileges and immunities of the United Nations, the Court notes that the United Nations has a responsibility to prevent and address abuses of the privileges and immunities of the organization and its personnel. The legal framework governing the privileges and immunities of the United Nations is not impervious to the legitimate concerns of members over such abuses. The privileges and immunities accorded to the United Nations and its personnel cannot be used as a shield for activities that are against the purposes and principles of the organization or are outside the functions of its personnel. Nonetheless, any concern of alleged abuse raised by a member regarding the United Nations or its personnel must be addressed within the existing legal framework for the settlement of differences. In any event, a member must not disregard its obligations under the Charter based solely on its unilateral assessment of the allegation. On the basis of the material before it, the Court notes that in response to the allegations concerning actions by Unrwa personnel, the United Nations took immediate action, launching 2 separate investigations, an internal one conducted by OIOS and an external one led by a group of independent experts. In the present context, it is important to reaffirm that a member has no right unilaterally to revoke the privileges and immunities accorded to the United Nations and its personnel, nor to abstain from performing the obligation that it has assumed. In the last section of its advisory opinion, the Court discusses the presence and activities of the United Nations in support of the right of the Palestinian people to self-determination. The Court is mindful that the present request for an advisory opinion has not arisen in isolation, but is situated in the context of Israel's prolonged occupation of the occupied Palestinian territory for more than 58 years, and the continued denial of the Palestinian people's right to self-determination. The Court recalls that Israel's territorial claim over East Jerusalem has long been declared null and void by Security Council Resolution 478, 1980 of 20 August 1980. The Court notes that the law to cease Unrwa operations in the territory of the State of Israel purports to apply to East Jerusalem. As an occupying power, Israel must refrain from extending its domestic laws to the occupied territory in any manner inconsistent with its obligation not to impede the Palestinian people from exercising its right to self-determination, including its inalienable right to territorial integrity over the entirety of the occupied Palestinian territory. Moreover, the humanitarian crisis in the Gaza Strip poses a direct risk to the living condition of the Palestinian people. The deprivation of the people of its essential means of subsistence threaten the fundamental conditions that are indispensable for the people to exercise its right to self-determination. Respect for the right to self-determination of the Palestinian people requires Israel not to prevent the fulfillment of the basic needs of the Palestinian people in the Gaza Strip, including by the United Nations, its entities, other international organizations, and third states. Lastly, UNRWA's unique mandate relates to the core aspect of the right of the Palestinian people to self-determination. The missions undertaken by UNRWA in the areas of direct relief, humanitarian and development assistance, through its programs covering education and training, healthcare, direct relief, and development services, are a manifestation of the organization's commitment to its responsibility with respect to the right of the Palestinian people to self-determination. Moreover, as noted earlier, since October 2023, UNRWA has remained the principal means and the backbone of all humanitarian response in the Gaza Strip, serving Palestinian refugees and civilians in urgent need of life-saving humanitarian assistance. In this connection, Israel is under an obligation not to impede the operation of the United Nations entities other international organizations and third states, and to cooperate in good faith with the United Nations to ensure respect for the right of the Palestinian people to self-determination. The Court reiterates that ultimately, the realization of the right of the Palestinian people to self-determination, including its right to an independent and sovereign state, living side by side in peace with the State of Israel, within secure and recognized borders for both states, as envisaged in resolution of the Security Council and General Assembly, would contribute to regional stability and the security of all states in the Middle East. For these reasons, the Court unanimously finds that it has jurisdiction to give the advisory opinion requested. 2, unanimously decides to comply with the request for an advisory opinion. 3, is of the opinion that the State of Israel, as an occupying power, is required to fulfill its obligations under international humanitarian law. These obligations include the following. A, unanimously, to ensure that the population of the occupied Palestinian territory has the essential supplies of daily life, including food, water, clothing, bedding, shelter, fuel, medical supplies, and services. B, by 10 votes to 1, to agree to and facilitate, by all means at its disposal, relief schemes on behalf of the population of the occupied Palestinian territory, so long as that population is inadequately supplied, as has been the case in the Gaza Strip, including relief provided by the United Nations and its entities, in particular, the United Nations Relief and Works Agency for Palestine refugees in the Near East, other international organizations and third states, and not to impede such relief. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Tladi. Against, Vice President Sebutinde. C, unanimously, to respect and protect all relief and medical personnel and facilities. D, unanimously, to respect the prohibition on forcible transfer and deportation in the occupied Palestinian territory. E, unanimously, to respect the right of protected persons from the occupied Palestinian territory who are detained by the State of Israel to be visited by the International Committee of the Red Cross. And F, unanimously, to respect the prohibition on the use of starvation of civilians as a method of warfare. 4, by 10 votes to 1, is of the opinion that, as an occupying power, the State of Israel has an obligation under international human rights law to respect, protect, and fulfill the human rights of the population of the occupied Palestinian territory, including through the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territory. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Tladi. Against, Vice President Sebutinde. 5, by 10 votes to 1, is of the opinion that the State of Israel has an obligation to cooperate in good faith with the United Nations by providing every assistance in any action it takes in accordance with the Charter of the United Nations, including the United Nations Relief and Works Agency for Palestine refugees in the Near East, in and in relation to the occupied Palestinian territory. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Tradi, against Vice President Sabatini. 6, by 10 votes to 1, is of the opinion that the State of Israel has an obligation under Article 105 of the Charter of the United Nations to ensure full respect for the privileges and immunities accorded to the United Nations, including its agencies and bodies and its officials, in and in relation to the occupied Palestinian territory. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Tradi. Against, Vice President Sabatini. 7, by 10 votes to 1, is of the opinion that the State of Israel has an obligation under Article 2 of the Convention on the Privileges and Immunities of the United Nations to ensure full respect for the inviolability of the premises of the United Nations, including those of the United Nations Relief and Works Agency for Palestine refugees in the Near East, and for the immunity of the property and assets of the organization from any form of interference. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Tradi. Against, Vice President Sabatini. 8, by 10 votes to 1, is of the opinion that the State of Israel has an obligation under Articles 5, 6, 7 of the Convention on the Privileges and Immunities of the United Nations to ensure full respect for the privileges and immunities accorded to the officials and experts on mission of the United Nations in and in relation to the occupied Palestinian territory. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Tradi. Against, Vice President Sabatini. I shall now call upon the registrar to read the operative part of the opinion in French.
Ces motifs, la Cour, 1, à l'unanimité, dit qu'elle a compétence pour donner l'avis consultatif demandé. 2, à l'unanimité, décide de donner suite à la demande d'avis consultatif. 3, est d'avis que l'État d'Israël, en tant que puissance occupante, doit s'acquitter des obligations qui lui incombent en vertu du droit international humanitaire. Ces obligations sont notamment les suivantes. A, à l'unanimité, faire en sorte que la population du territoire palestinien occupé dispose des produits essentiels à la vie quotidienne, notamment l'eau, la nourriture, les vêtements, le matériel de couchage, les abris et le combustible, ainsi que des articles et services médicaux. B, par 10 voix contre 1. Accepter et faciliter dans toute la mesure de ses moyens les actions de secours faites en faveur de la population du territoire palestinien occupé, tant que cette population est insuffisamment approvisionnée, comme cela a été observé dans la bande de Gaza, y compris les actions de secours menées par l'Organisation des Nations Unies et ses entités, en particulier l'Office de secours et de travaux des Nations Unies pour les réfugiés de Palestine dans le Proche-Orient, et par des organisations internationales et des États tiers, et ne pas empêcher de telles actions. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Shue, M. Nolte, Mme Charlesworth, M. Brandt, Gomez, Robledo, Mme Cleveland, M. Tladi, juge, contre Mme Sebutinde, vice-présidente. C, à l'unanimité, respecter et protéger tout le personnel de secours et le personnel médical ainsi que leurs locaux. D, à l'unanimité, respecter l'interdiction du transfert forcé et de la déportation dans le territoire palestinien occupé. E, à l'unanimité, respecter le droit des personnes protégées du territoire palestinien occupé qui sont détenues par l'État d'Israël de recevoir la visite du Comité international de la Croix-Rouge. F, à l'unanimité, respecter l'interdiction d'utiliser contre les civils la famine comme méthode de guerre. 4, par 10 voix contre 1, est d'avis que, en tant que puissance occupante, l'État d'Israël a l'obligation, en vertu du droit international des droits de l'homme, de respecter, de protéger et de réaliser les droits de l'homme de la population du territoire palestinien occupé, y compris par la présence et les activités de l'Organisation des Nations Unies, d'autres organisations internationales et d'États tiers dans le territoire palestinien occupé et en lien avec celui-ci. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Bran, Gomez-Robledo, Mme Cleveland, M. Tladi, juge, contre Mme Sebutinde, vice-présidente. 5. Par 10 voix contre 1, est d'avis que l'État d'Israël a l'obligation de coopérer de bonne foi avec l'Organisation des Nations Unies en lui donnant pleine assistance dans toute action entreprise par elle, conformément à la Charte des Nations Unies, y compris par l'Office de secours et de travaux des Nations Unies pour les réfugiés de Palestine dans le Proche-Orient, dans le territoire palestinien occupé et en lien avec celui-ci. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Bran, Gomez-Robledo, Mme Cleveland, M. Tladi, juge, contre Mme Sebutinde, vice-présidente. 6. Par 10 voix contre 1, est d'avis que l'État d'Israël a l'obligation, en vertu de l'article 105 de la Charte des Nations Unies, d'assurer le plein respect des privilèges et immunités accordés à l'Organisation des Nations Unies, y compris ses organismes et organes et à ses fonctionnaires, dans le territoire palestinien occupé et en lien avec celui-ci. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Brand, Gomez-Robledo, Mme Cleveland, M. Tladi, juge, contre Mme Sebutinde, vice-présidente. 7. Par 10 voix contre 1, est d'avis que l'État d'Israël a l'obligation, en vertu de l'article 2 de la Convention sur les privilèges et immunités des Nations Unies, d'assurer le plein respect de l'inviolabilité des locaux de l'Organisation des Nations Unies, y compris ceux de l'Office de secours et de travaux des Nations Unies pour les réfugiés de Palestine dans le Proche-Orient, et de l'exemption des biens et avoirs de l'organisation de toute forme de contrainte. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Bran, Gomez-Robledo, Mme Cleveland, M. Tladi, juge, contre Mme Sebutinde, vice-présidente. 8. Par 10 voix contre 1, est d'avis que l'État d'Israël a l'obligation, en vertu des articles 5, 6 et 7 de la Convention sur les privilèges et immunités des Nations Unies, d'assurer le plein respect des privilèges et immunités accordés aux fonctionnaires de l'Organisation des Nations Unies et aux experts en mission pour l'organisation dans le territoire palestinien occupé et en lien avec celui-ci. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Bran, Gomez-Robledo, Mme Cleveland, M. Tladi, juge, contre Mme Sebutinde, vice-présidente.
Vice President Sebutinde appends a separate opinion to the advisory opinion of the court. Judges Abraham and Cleveland appends a joint declaration to the advisory opinion of the court. Judge Shue appends a separate opinion to the advisory opinion of the court. Judge Charlesworth appends a declaration to the advisory opinion of the court. Judge Brandt appends a separate opinion to the advisory opinion of the court. Judge Gomez-Robledo appends a partially dissenting opinion to the advisory opinion of the court. Judges Cleveland and Tladi append declaration to the advisory opinion of the court. The text of the opinion is available from today in TypeScript. It will also be available almost immediately on the court's website. The printed text will be available in the near future. As the court has no other business before it, I declare the sitting closed.